evening from my home to your home. As part of BTOs, where there's a will, there's a way update and educational sessions, which have been postponed owing to lockdown, we wanted to make contact with our clients and contacts and let you know that we are still here and still available for any questions you may have regarding your own personal affairs, updating of your wills, review of powers of attorney, and any tax planning that you might be considering. At a time when we have more forced at home time, we're finding that many clients are working through their to-do lists, and often on that to-do list is the preparation of a will or the update of an existing will. And what we thought would be beneficial would be for me to run through with you just some of the basic questions that I'm often asked. So with that in mind, we thought it would be beneficial to put together a short video just reminding you of the things that you need to consider when you are either putting a will in place for the first time or when you are considering a possible update to your existing will. One of the first things that you need to consider is the appointment of your executors. The executors are the individuals that will liaise with the solicitor and pull together the information that's required to be lodged with both the court and HMRC. Ideally, those individuals should be your age or younger, and ideally 2, but sometimes 3 individuals are appointed as your executors. In a husband and wife situation, we would always say that the surviving husband or wife is appointed as first named executor, unless there's any medical reasons why that shouldn't happen. But we would always say your first executor in that situation would be your spouse, and then to consider who should be your second and potentially third named executors. Often we're asked if a beneficiary can be an executor, or the fact that they are a beneficiary, does that exclude them from being appointed as an executor? And the answer to that is no, that they are not excluded, and that yes, a beneficiary can act as an executor on your estate. As part of that process of considering who should be appointed as your executors, often clients say, do I need to advise the executor that I am appointing him or her as executor? And that's really up to you whether you want to do that. Sometimes clients are keen to advise their executors of the fact that they have appointed them as their executor, and sometimes they'll actually say, let me hold on, because I want to consult with that person first just to confirm that they are quite happy to act. The main thing here is the will that you prepare might not be your last will and testament. So if you have advised someone that you have appointed them as your executor, it may be that at the time of your death that you have updated the will and that they are actually no longer an executor. It's entirely up to you what you want to do regarding advising executors, and then always remembering to advise them subsequently if you have updated your will and that they are no longer executors. Once you've considered executors, it's then whether or not you want to leave any specific bequests called legacies. So it can be cash legacies or specific items that you're leaving to individuals or to charities. So you would then consider those legacies and also consider what should happen if your named recipient should die before you. If you're leaving it, say, to your sister, should you then be saying, well, okay, and if my sister dies before me, does it then pass to her children? And if it is passing to her children, are we saying that any funds or assets that are being held for those young children are held back until they are older? If the will is silent on the age that younger beneficiaries receive their inheritance, they'll inherit at age 16. And if we want to delay that inheritance, we have to specifically state that the inheritance will not be paid over until a specific age. Most common is to say that assets will be held back until 18, 21, 25, something like that. So that's the specific bequests. Then when we've dealt with specific bequests, the remaining assets in your estate are known then as the residue of your estate, and you have to think, who is it that should receive that residue of your estate? Should it be one individual, or should it be a number of individuals? If it's all going to one individual, what happens if that individual should die before you? Who should receive in his or her place? Likewise, if you are receiving or leaving it, to a number of beneficiaries, should they predecease you, what should happen to that beneficiary's share? So these are things that you will be asked at any meeting with the solicitor to consider. So that's in the residue of your estate. Often clients arrive thinking that they want to leave their estate, their residue, to their partner and to leave it to them outright. But it's not until we maybe discuss the various other options that they change that instruction, they amend that instruction, because they don't want their partner to inherit everything absolutely. The reason for that is that they don't want the wealth to accumulate in the name of the surviving spouse, or that the surviving spouse may remarry, and then on that remarriage might pass the assets to the new husband or wife, and those assets will include the assets that they have inherited from first husband and wife. And the risk that you run there is that the children of the marriage don't receive all that the now deceased parent would have wanted them to receive, because the surviving parent has married again, and assets are then being made over to the new husband or wife. To safeguard against that and to make sure that your ultimate beneficiary, so in the case of a husband and wife and children, that your ultimate beneficiaries there might be your children. So you're saying, okay, yes, I want to look after my surviving husband, but I want to make sure that inheritance, if possible, is there to pass to my children. So what we do there is we incorporate a life rent provision into a will to safeguard those assets for the next generation. Life rent arrangement is something that's far more common these days, and there are a variety of reasons why we would be suggesting that option to clients. It's still inheritance tax efficient, and inheritance tax is a complete subject on its own, but it's something that we do go over with clients when we're taking the will instructions. We need to know approximate value and makeup of assets to make sure that all assets are considered and their values are considered, so that we can advise you whether or not there is a potential tax liability there. And also, some assets don't sit within the four corners of your will. The succession to some assets doesn't matter what you put in the terms of your will. They who inherits those assets on your death is governed by other documentation, other paperwork that you may have signed. Now, sometimes that comes as a surprise to clients, but the most common things are pension arrangements. That's not going to be governed by the terms of your will. And if you have a life policy and that life policy is written in trust, that policy isn't going to pay out to your estate, it's going to pay out to your named trustees under that life policy. So that's not governed by the terms of your will. So part of that initial will discussion that we have will cover off the assets in your estate and also the makeup of your family. just to see who you are including in the provisions of your will, and sometimes more importantly who you are excluding, and whether or not we need to discuss the Scots concept of legal rights, which says that an individual can't exclude their spouse or civil partner and children and grandchildren, if there are predeceasing children, from your will. So that's something that we would go over when we were looking at the makeup of your estate and the individual family members. So that's then residue, and whether or not residue should be paid over absolutely to your named beneficiaries, or if we need to include this life rent trust provision to make sure that your assets, or a particular asset, sometimes we put in place a life rent trust provision and it's just governing the succession to your interest in your property. Because with the majority of clients, we find that the biggest asset they have is their home, or their interest in their home, and they want to maybe just safeguard that for the next generation, for their children. Other trust arrangements that we might consider with clients when we're putting their wills in place is a trust, as I previously mentioned, for younger beneficiaries. So we'll hold back assets until a certain age. So that could be a trust provision that's there in terms of your will. We have the life rent trust, which is the one that I've discussed, where we're saying, okay, the surviving spouse can have a life rent interest in an asset, but it doesn't become theirs absolutely. Other type of trust which is often requested is a trust for a family member when, because of either illness or outside influences, that family member isn't able to look after their own finances, and the grantor of the will, the client, wants to make sure that there are some safeguards in place to make sure that that individual isn't suddenly receiving tens or hundreds of thousands of pounds of inheritance, and they can't look after that. So in that situation, we would recommend, and the clients would want, a trust arrangement in place. There's a variety of trusts that we use, depending on the circumstances. So again, when we are considering putting wills in place and trusts in place, we've then got to think, okay, you have to think wisely about your appointment of your executors, because those executors then become the trustees of that ongoing trust arrangement, and that trust arrangement could last for quite a few years. Quite often when we set up a trust arrangement, the client will put together a letter of wishes, which is something that sits beside your will, sits alongside your will, and it's your way of putting in plain English your views and your thoughts, so that when your trustees have to make decisions, is that they are able to refer back to that letter of wishes and see what you had in mind when you were putting that will together. Quite often I ask parents to prepare a letter of wishes when there are younger beneficiaries and they're asking trustees to make decisions about when funds are paid over to those younger beneficiaries. I might ask them to put together that letter of wishes to say, well, okay, when should they be paying money over and when shouldn't they be paying money over? Because some parents have strong views on things like, okay, definitely don't purchase a motorbike for my son or daughter, or encourage travel, or don't encourage travel. Sometimes clients will put in their letter of wishes, okay, if there's a gap year, that gap year can't be funded from the trust fund. So it's just a way of putting together your views on things that you've maybe not had time to discuss with your trustees and those individuals that you're appointing as your trustees. So those are kind of the main things to consider when you are pulling together your will and thinking about your will. The main thing is that yes, we all need one and we should have one in place, and I understand that it's often the thing that's at the bottom of the to-do list, but a time like this, it's quite a good time to pull that higher up the to-do list and realise that the individuals that are dealing with your will and succession planning advice here in BTO are still here, and we are friendly, approachable individuals, and I appreciate that the subject matter isn't the liveliest and the happiest, but it's something that we all do need to consider. And I often say to clients, you just consider it, you prepare the will, you sign the will, and then you carry on living, and hopefully we don't need to pull that will out the safe for a long time. And with that in mind, what we are suggesting and what we have put in place here at BTO is a 20-minute free consultation with one of our solicitors here to discuss things that you might be concerned about at this time of lockdown. Now, what may happen is that you're making that call to us and we tell you that, yeah, everything's okay. And it's just that reassurance that you need that the paperwork that we're holding or the paperwork that you have at home is all in order and doesn't need any amendment. Or alternatively, it could be that lockdown and having time at home to consider things, you might be thinking, okay, somebody that you've referred to in your will is now somebody that you don't want to inherit any aspect of your estate, and that you want to update your will. So again, we can assist with that. The signing procedures since lockdown have changed, so don't think that when you call us there will then be this delay until lockdown is removed before paperwork can be prepared and signed off. We can now sign and witness documentation for clients via video link up, because often clients will say, well, how can I obtain a witness to sign my will if I am self-isolating and nobody can come into the property? And there we link up by a video link up and do the witnessing that way. If a client doesn't have a video link up, and what we've had to do occasionally recently for notarial executions is to actually go out and visit the client at home and talk to the client through the window and watch that client sign that document through the window and speak to the client via mobile phone, just to make sure that will is signed off and that the client has the peace of mind that everything's in order. So main message here today or this evening is just to say that it is business as usual, and please do pick up the phone or email us if you have any questions at all. Yeah, have a lovely lockdown, and you know where we are. Okay, bye.